Guys, I'm not even gonna do an intro because I am so pissed off. There are no words right now to describe how outrageous this ruling by Judge Lyman was.
The judge has dismissed altogether the $400 million defamation lawsuit filed by director Justin Baldoni against Hollywood power couple Blake Lively and Ryan Reynolds.
It is beyond ridiculous. It's a slap in the face to every woman who is a true victim, to every woman who is not believed, who truly has suffered sexual harassment, sexual assault.
In a stunning development in Hollywood's latest legal showdown, a judge has dismissed significant portions of Justin Baldoni's lawsuit against Blake Lively.
This story reveals a new playbook for waging a smear campaign in the digital age.
After an extensive review spanning more than 130 pages, the court's decision marks a critical turning point in this high-profile case between the two actors. Stay tuned as we break down the key details and what this means moving forward.
A campaign to tarnish Lively after she alleged misconduct while shooting the film.
I am so sorry to bring this terrible news to everyone that the judge granted motion to dismiss Justin Baldoni's lawsuit against Blake Lively, Ryan Reynolds, their publicists, and the New York Times. So what does this mean for Baldoni? It means that this is a major legal setback, obviously. So the judge here says that his claims were not legally sufficient.
On Monday, the judge in the Southern District of New York officially dismissed Justin Baldoni's amended complaint against Blake Lively, Ryan Reynolds, the New York Times, and PR representative Leslie Sloan. This was a motion to dismiss, a preliminary challenge to determine whether a case should move forward. And according to the judge, Baldoni and his team did not meet the legal threshold.
This isn't my night.
Now, we'll likely do a deeper dive on this tomorrow, but here's a quick breakdown of why the lawsuit was thrown out.
You gotta stop. You have to stop this. Please.
Lively had accused Baldoni, her co-star and director on It Ends With Us, sexual harassment during production, and claimed that he and his team launched a smear campaign against her in the media.
We take it very, very seriously.
Baldoni fired back, alleging that Lively hijacked the film's production and used false accusations to damage his career. He also sued the New York Times, alleging they published a biased article against him, but Judge Louis J. Lyman dismissed the claims. Civil extortion claim dismissed. The court found no extortion under California law, regardless of the propriety of these actions. They do not constitute civil extortion under California law. The judge ruled that Lively's actions, including demands around film control and promotional obligations, constituted hard bargaining rather than unlawful threats. Even if aggressive, these actions didn't rise to the level of extortion. Baldoni had claimed extortion based on Lively refusing to return to set unless her demands were met, threats to skip promotional obligations unless her version of the film was shown, a supposed demand that Baldoni be excluded from the premiere, alleged threats by Lively and Reynolds to criticize Wayfarer publicly if it didn't take blame for on-set problems. But the judge said these allegations were conclusory and lacked specifics, didn't result in damages, involved threats to withhold action, not engage in illegal behavior, didn't include threats of false legal action or physical harm. Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from the threat. Also, a threat to breach a contract by itself is not extortion, so no wrongful conduct, no disproportionate exchange, and most importantly, no damages. The judge found that Wayfarer hadn't shown actual monetary harm caused by Lively's alleged threats. Defamation claim also dismissed to win a defamation case. Especially when public figures are involved, the plaintiff must prove a false defamatory statement was made. It was published to a third party. The speaker knew it was false or acted with reckless disregard for the truth. Here, the court found that the defamation allegations were too vague and didn't meet the legal standard. The Wayfarer parties had alleged Lively, Reynolds, and Sloan conspired to spread false narratives accusing them of misconduct. The New York Times defamed them by publishing these claims. However, the court said statements made in Lively's legal complaint are protected by litigation privilege. There's no evidence that Reynolds, Sloan, or the Times made statements with actual malice, i.e. knowing falsity or reckless disregard for the truth. The Wayfarer parties have not alleged that Lively is responsible for any statements other than the statements in her complaint, which are privileged. And regarding Reynolds, Sloan, and the Times, the Wayfarer parties have not not alleged that these defendants seriously doubted the truth of their statements. This decision is a major blow to Baldoni and his production company. The judge's opinion essentially frames the entire situation as a contractual dispute, not criminal conduct. Hard bargaining and creative differences? Maybe, but extortion or defamation? The court says absolutely not. We'll be back soon with a deeper analysis of the ruling and what it means for both parties moving forward.
You were teaching Justin how to pull you in.
Where have you seen this?
I don't think people realize how involved she was in this movie. And she's a producer on the film from the beginning to the end. She was extremely involved, and she really made the film better.
History with Justin also was off the charts. I mean, really, truly, you fell in love with both couples, you know, with Lily, with both of them. And Blake, you always have a vision. So talk to me about how sometimes you were even the intimacy coordinator in some of those sexier scenes. Like we saw you.
That shouldn't be happening, by the way. I just want to be clear that you should not be the intimacy coordinator. You should definitely hire intimacy coordinators, which we did have, thank goodness.
You were teaching Justin how to pull you in.
Where have you seen
this?
I actually just saw it too. It was on Instagram yesterday, I think.
Yeah, I mean, I think that, like, you know, romance is really important. You're supposed to, you know, tell a story well and make people feel, but you're also supposed to do it in a way that, yeah, is like safe and respectful for all. So yeah, I guess that's the role of intimacy coordination. But yeah, when I think of my involvement in the film, I don't really see that as the thing that I did. I did probably everything else. You touched on everything else here and there, but yeah, we were really lucky I'm fortunate to be able to have had, you know, such a all-encompassing experience on this film, and Colleen too.